Hi everyone. The question of international law within the European Union, and in particular within European Union law, is a quite relevant question, quite relevant topic in international law, and at the same time a quite controversial issue. And this is the case because of the different types of approaches the EU has taken with regard to international law. There are different elements there that we need to consider in order to understand what is the consideration, the role of international law in the EU, and in particular in EU law. The first consideration is what is or regards the question of the nature of the European Union in the context of international law. The second element that we need to take into consideration is the evolving jurisprudence case law of the Court of Justice with regard to the relations between international law and EU law. And the third element is the different types of interactions and relations between international law and EU law as per the treaties and as per the case law of the Court of Justice of the European Union. And finally, we need to address the issue of conflict or the potential clashes between international law and EU law. So to start with, in terms of the EU and its legal personality, the EU is an international organization which was created by the EEC treaties, the Treaty of Rome, the Treaty of Paris, and these founding treaties were concluded in light or within the international law system. So therefore, they are regulated by international law, the law of treaties. And so if we look now at the current treaties, the Treaty on the Functioning of the European Union, TFEU, and the Treaty on the European Union, TEU, and the Euratom Treaty, they are regulated by international law, by the law of treaty, mainly now the Vienna Convention on the Law of Treaties, VCLT. So this is quite relevant if we consider the case of Brexit. Right? If we look, for instance, at Articles 48 to 50 of the Treaty of the European Union, we will see that all the aspects related to the accession, membership, and also withdrawal from the EU, in addition to being regulated in EU law, they are regulated by international law norms. And we expect to see lots of these issues arising in the context of Brexit, in particular in the post-Brexit context. So we should bear in mind that part of the constitutional norms of EU law are rooted in international law. So the founding treaties, in particular the TFEU, in Article 249, they attribute the lawmaking powers to the institutions, to the EU institutions, and therefore there is this clear attribution to the institutions, right, to generate a supranational legal order. And in this regard, when it comes to the legal nature of the European Union, clearly it's an international organization, but it is an international organization of specific nature, a supranational international organization based on the powers that the different member states have given to the international organization. So in terms of the international legal order, the EU, is a subject of international law, which is bound to respect international law, both customary international law and international treaty law. But also the EU is endowed with the power to conclude treaties. And in this regard, the EU is a quite active subject of international law, with participation in different areas of international law and in the conclusion of different treaties. For instance, the EU has shown a quite active role in the conclusion of free trade agreements within its specific competencies, and I think this is also quite interesting to note. The EU has different types of competencies, and clearly whenever the EU has a competence internally attributed by member states, for instance, like in the area of commercial policy, that competence is mirrored externally as well. So therefore, for instance, when talking about specifically about common commercial policy, the EU has the competence given by the states to conclude free trade agreements, free trade and investment agreements with third states. Equally important, we need to distinguish another type of treaties concluded by both the member states and the EU, which are the mixed agreements, in areas in which both the EU and the member states have competences, such as in the case of environmental matters. For instance, the EU and the member states have concluded the Kyoto Protocol and the Paris Agreement. So the EU clearly is a subject of international law, which enjoys all the different rights of international law subjects, right? In particular, with regard to the conclusion of international treaties. At the same time, the EU is a member of different international organizations. As a clear example of this, we can mention the membership of the World Trade Organization. So therefore, the EU is bound to respect the Marrakesh Agreement, creating the WTO, but also all the GATT agreements. So that gives us the idea of how the international law has contributed to the creation of the EU and to the creation of EU law. In terms of the consideration of international law within the EU legal order, we need to distinguish the different elements of international law. Clearly, customary international law is an integral part of EU law, and so it is international treaty law. In terms of customary international law, the EU is bound to respect customary international law rules and has clearly recognized the different norms and rules applicable to different areas, such as state immunity or the treatment that the states grant to their own nationals, and in other areas such as in terms of the protection of human rights and refugees. In terms of international treaty law, the consideration of international law as an integral part of EU law has to be analyzed in light of the case law of the Court of Justice of the European Union. In some cases, for instance, in particular with regard to some treaties, right? So the Court of Justice of the European Union has has taken different stances. Right? So when it comes to international treaty law, we will see that in some cases the Court of Justice has questioned the idea of succession of obligations under international treaty law. For instance, in United Fruit case, in which there was the question of obligations assumed by member states under the GATT, and then the EU as a successor to the member states, and the interpretation there was quite strict, right, on the part of the court. So we will see that in different cases, international treaty law, although being an integral part of EU law, has been interpreted or its effect limited based on the particular characteristics of the case or the particular characteristics of the norm. There are three different ways in which international law is introduced and also considered within the EU legal system. One is through the question of direct effect, and then we have the consistent interpretation as well. And we have as well the question there of the borrowing between international law and EU law, particularly the borrowing of international law elements, right, by EU law. In terms of the direct effect of international norms, this is quite clear, and there is a doctrine there regarding direct effect. And whenever we have a sufficiently clear, precise, and unconditional norm, that norm can produce direct effect, which means it can be automatically applicable without any act of transformation or transposition into national law, in this case EU law. And we have had this quite established doctrine for a while. However, in some cases, the Court of Justice, based on the nature and the structure of the obligations undertaken, in particular with regard to certain treaties, the Court of Justice has limited the direct effect of international norms. This has been the case of the decisions by the World Trade Organization based on the nature and the structure of the treaties, and also the case of UNCLOS, the United Nations Convention on the Law of the Sea. Clearly, in these cases, because of the structure and the nature of the international norm, and because the norm, according to the Court of Justice, did not fulfill the three requirements, direct effect was limited. So we can see this as a sort of a filtering on the part of the Court of Justice of international law norms, and wherever the norm does not meet the requirements for the reasons I mentioned before, then direct effect is also limited. So the second process, or the second interaction that we have between international law and EU law, is the question of the consistent interpretation. EU law norms are interpreted in light of international law norms, and we have in the different areas of activity of the European Union different examples. For instance, in terms of the common commercial policy, in terms of the protection of human rights. So there is a clear interaction there in which international law is taken into consideration as tool for interpreting EU law. And finally, there is this interaction or substantive borrowing between the two different legal orders. Right? So in particular, the EU borrows from international law whenever there is a gap or a lack of a specific norm in EU law. So therefore, we can say that international law has this gap filling function with regard to EU law. So this is as to the interactions between the different legal orders. Right? And in terms of the specific consideration of international law within EU law, as I mentioned before, and I hope that that's clear, international law is considered an integral part of EU law. However, the question of the hierarchy is controversial. So if we look at EU law and the different norms of EU law, international law clearly ranks above secondary EU law, above the directives and regulations and decisions. It has a higher nature and hierarchy. And it is on the same level as the primary law norms. However, in certain areas, such as with regard to norms which are peremptory norms in international law, just called norms, international law would take precedence over EU law. So international law would prevail over EU law. That would be the rule. Of course, as I also pointed out at the beginning, there have been cases, more recent cases, in which the relationship in terms of hierarchy as well has been questioned. And I'm referring to, in particular, the CADI cases. There were two cases, one in 2008 and the second one in 2013, and both concerning the application of sanctions by the Security Council on individuals who were put on a list and subject to sanctions such as asset freezing due to questions regarding terrorism and counterterrorism. Right? So these individuals who had been suspected, right, and placed on this list were subject to sanctions without proper remedy on the international level. And clearly they challenged the implementation of this decision by the Security Council in the EU. And then therefore the Court of Justice was faced with the issue of deciding a case in which human rights were at stake. In both cases, the Court of Justice came up with arguments about the nature of EU law and about the relations between EU law and international law. In one of the cases, in particular the first one, CADI 1, the Court of Justice based the decision on different arguments. One of the first arguments, and this is in terms of the relevance of the arguments, was that the EU was not bound to respect the UN Charter, as the EU is not a member of the UN. Of course, this is a bit in itself controversial, as the EU is bound to respect international law and general international law norms, but this was one of the arguments. The second argument was about the autonomy of EU law and the constitutional nature of the treaties. And here, clearly, what the Court of Justice did was to review the sanctions in light of EU law, emphasizing this idea of EU law as a constitutional legal order and as autonomous. So, if we may, the Court of Justice took a dualist position with regard to the relations between international law and EU law. And as you may see, this is quite controversial, right? Because up to that point, up to 2008, more or less, the consideration of international law within the EU context has been more from the perspective of a monism, or from a more monist perspective. Right? And the third point here in the analysis, in a very succinct summary of the case, was with regard to the constitutional principles of EU law, the constitutional nature of the EU Charter of Fundamental Rights, and therefore the Court of Justice ruled, right, against the sanctions upholding the protection of human rights. So, as I said, this was a turning point for the relations between international law and EU law. The first case was more based on the autonomy of EU law and on the idea of separate legal regimes. Right? So the second Cali case has contributed more arguments in favor, right, of this idea of a specialized legal order with a certain autonomy, but also taking into consideration, right, the specific incardination of EU law within international law. After the Cadi case, in other areas of international law, we have seen the attempts, right, from the part of the Court of Justice, right, to reivindicate the autonomy of EU law. Outside the field of human rights, we have seen in the investment law field, with regard to the Energy Charter Treaty, a clear stance of the EU on the issue of autonomy of EU law, and clearly a questioning of the interpretation and application of EU law by international investment tribunals. So clearly, what this trend may mean for us in terms of the relations between international law and EU law is that there is a growing consideration towards the autonomy of EU law, which clashes sometimes with international law. So this is something that is quite current and quite controversial. Right? So how can we solve these different clashes? Right? So, and this is part of what we have seen in international law as fragmentation. Right? So there are different ways to go about these conflicts or clashes. Right? And one clear way is through the consistent interpretation and through the use of interpretation as the main tool. We should not forget that in the Vienna Convention of the Law of Treaties, right, in Article 31, we have different interpretative tools, and one of them calls on states to interpret international law as a whole. And so I would say that from the perspective of international law, clearly is the Vienna Convention, is Article 31. From the perspective of EU law, is a consistent interpretation tool, and by using both approaches, right? So we should try to strike a balance and to interpret international law in a way which is also consistent with EU law, respecting the peculiarities of both legal systems. So in terms of a final reflection, considering the relations between international law and EU law, clearly international law is a core element in the creation and consolidation of the European Union, is an integral part of EU law, and it is still ranking on top of the hierarchy. In terms of the question of the potential conflict between international law and EU law, as I mentioned before, the way to deal with these conflicts should be by an interpretation and by a consistent interpretation of international of EU law in light of international law. And for the future, right, it is to be expected that with the different elements, right, as previously set out there, right, we will see more cases in which international law or international law elements will be applied in EU law. But I would like to conclude with this idea that the relation and the interaction between international law and EU law is of a mutual influence and is quite fruitful relation in which both legal orders have benefited from, and that although there are conflicts and clashes in particular areas such as the trade realm or with regard to counterterrorism, there are common values and common principles which are shared by both legal orders, such as in the area of international human rights law and the protection of fundamental rights.